talks about required religious practices in public schools, and it's pretty similar to the early case Engel versus Vitale. So a bit of context, it started in 1956 and ended in 1963, and it occurred in Pennsylvania, which is pretty important to know because at the time, Pennsylvania was one of 5 states that had the specific law in contest, and the law said that at least 10 verses from the Holy Bible be read without comment at the opening of each public school on each school day. So that was the law that the Schempp family decided to challenge. And Ellery Schempp was a high school student in the Abington School District, and he identified as a Unitarian Universalist. And that's a religion that doesn't really have a specific doctrine, but they talk about inclusive love and spiritual growth. So during the time designated for prayer, he brought in a copy of the Quran and read from that instead. And because of that, he was sent to the principal's office. So his father decided to file a lawsuit against the Abington School District. And the charges that he cited were he claimed that the law violated his family rights and that the law was contrary to his religious beliefs and his familial teachings. And he cited the First and the 14th Amendment. So in district courts, because his children were under 18, he was forced to testify with them. So his children during the trial testified that they had been forced to read and or listen to Bible verses that were contrary to their personal and religious beliefs. And their father, Edward Schempp, even said that he had considered making them miss school because of the law, but he didn't want to adversely affect their relationships with their peers. In the district courts, they ended up ruling in favor of the Schempp family, and they struck down the Pennsylvania law. But the school district decided to appeal to the Supreme Court because they didn't agree with it. However, in the meantime, between when it was in the district court and the Supreme Court, the Abington School District decided to amend the law. So they said that any student who had a written request from their parent would be allowed to be excused from prayer. However, the Schempp family wasn't satisfied, so they pursued it further. And the case finally reached the Supreme Court in 1963. The Chief Justice at the time was Earl Warren, and he was the Chief Justice during Engel versus Vitale. And that's important because there was still a lot of backlash from that case. So the Supreme Court kind of used Abington versus Schempp as a way to support and reiterate their ruling on the issue. And they ended up upholding the district ruling with an 8-1 vote. And they said that they had already settled that the Establishment Clause applied to the states and that the Pennsylvania law ended up breaking the 14th Amendment. Specifically to the case, the Supreme Court argued that the Abington law encroached on the free exercise and Establishment Clause, and that because the prayers and recitation were religious in nature and were intended to be religious, that they were a violation. They also said that even though there was an amendment which allowed students to be excused from prayer, it was irrelevant because the district was violating the Establishment Clause regardless. And it's important to know that up until this point, Abington versus Schempp was pretty similar to Engel versus Vitale. However, Justice Clark really set this apart from that case when he said that the job of the Establishment Clause was to protect all, prefer none, and disparage none, referring to religion, or to the Establishment Clause rather, because up until this point, it had kind of been a point of contention that all the Establishment Clause did was keep the government from preferring one faith over another. This case was controversial, of course, so it created a large divide in public opinion, and there was obviously a huge divide between religions. Generally, the Protestants and Jews were more supportive of this, whereas conservative Catholics were usually against it. And the divide in religion, or the divide in public support, was seen pretty clearly in how the newspapers responded to it. Papers like the Washington Star were against it, and they said that God and religion have all but been driven from public schools. What remains? Whereas papers like the New York Times published